Well, hey folks, day 7 of Lori Vallow Daybell Arizona trial unfolded with a mix of procedural milestones and an intense courtroom drama as the prosecution rested its case, and Lori, representing herself, chose not to present a defense. But she didn't quite rest, so I'm not quite sure what she's doing, but I think she's still in control because she's still thinking about whether she's going to testify. But frankly, she's running out of time. So my question's going to be, has she just thrown in the towel, or is this what she planned all along so that the self-proclaimed prophetess can preach to the world about their sin in convicting her and her doomsday husband, Chad Daybell? Hey, welcome to Profiling Evil, where we dig into the facts, we explore the psychology, and we break down the criminal behavior one case at a time. Now, if you're into true crime without any of the nonsense, make sure you're hitting that like and subscribe button down below. And please ring the bell so that you get the notifications and you never miss a moment of the madness. Now buckle up, folks, because we're heading into the courtroom, straight into the heart of this cult ideology clash with cold, hard evidence. And the stakes couldn't be higher. This is day 7 of Lori Vallow Daybell's murder trial in Arizona for murdering her 4th husband, Charles Vallow. Now, the prosecution ended the day by resting their case, and Lori, she stunned everyone by resting hers without calling a single witness. No testimony, no defense. Just Lori standing at the helm of her own sinking ship. Although she did file a Rule 20 motion kind of as a last-ditch Hail Mary. We'll talk about all that a little later. But the highlight and the low light was her bizarre cross-examination of the veteran homicide detective named Duncan. So let's examine the day from this religious delusion point of view all the way over to digital forensics. And I want to start with Duncan's testimony. Detective Duncan stepped up to the witness stand, bringing with him 25 years of experience with the Chandler Police Department. His resume is no joke. This is a guy who's been on patrol. He's worked property crimes, and for the last decade, he's worked homicide. He's not a rookie to crime scenes, nor to digital forensics, and he made it clear from the get-go that he's familiar with everything from cell phone data to cloud-based data extractions. And on the day that Charles Vallow was killed, Duncan was on duty. He first heard about the incident over the radio, and moments later, he got the assignment to head to the scene and to help with the investigation. Now, when Duncan arrived at the house, he saw the usual signs of a major event. There was crime scene tape put up, emergency vehicles, officers walking back and forth as they secured the perimeter. And Alex Cox, he was already outside, sitting on the curb. Lori Vallow? Who knew? She was nowhere to be seen. She had, as we would later learn, already left the house, allegedly to take JJ to school and to run some errands. You know, normal things you do when your husband's been shot and killed. She also had Charles's phone and his wallet in her possession. Now, inside the home, Duncan and the other detectives were waiting until a search warrant could be signed. But once inside, what struck Duncan the most was just how neat the crime scene was. It was almost unnatural for a shooting death. Charles's body was lying flat on his back, with his arms out to the side, in what Duncan called a supine position. He was laying in the middle, actually to the side of an empty room. There wasn't any blood spatter. There were no bloody footprints. There were no cleanup tools like towels or rags. There was only a small smear of blood that was found on the kitchen faucet. and a small amount of blood in the webbing of Charles's left hand, likely from him placing his hand on his chest after he was shot. Now, this seemed kind of inconsistent to the detective, with somebody who was, at least according to Alex, saying there was a violent confrontation just before the shots rang out. This pristine crime scene, by all accounts, combined with the forensic detail of bullet strikes under Charles's body at that left shoulder, became a big moment. Now, it supported the theory that Charles was shot while he was lying on the ground, not standing up in self-defense range as Alex claimed. Duncan processed the weapon that was recovered. It was a Springfield XD .45 caliber handgun, and it was found near an orange duffel bag in what they nicknamed the little room called the pink bedroom. And I assume that was because of its decor. Now, he made the gun safe, but he found as he was making it safe that it still had a round in the chamber, and there were extra magazines lying nearby it. Importantly, the gun had no blood on it. Another crack in Alex's story about this struggle that happened. And in the duffel bag, there was a debit card for Alex Cox, and this small detail would later grow into something much larger because it solidified that Alex owned the gun, and it helped anchor him directly to the scene, and most importantly, to the weapon that killed Charles Vallow. And here's where Duncan's testimony took a sharp turn. It kind of went from forensics to digital breadcrumbs, because he was later reassigned as the lead detective on the case, and he began working through all of the digital evidence. Specifically, he was tasked with organizing and interpreting iCloud accounts, cell phone data, text messages, and email accounts that were tied to Lori, to Charles, and to Alex. And one of the biggest discoveries came from an email that Charles found, allegedly, that was sent to him from Chad Daybell. The problem is that Charles never wrote that email. The email came from a fake account that was created using Lori Vallow's old phone number. That forged email invited Chad Daybell to come to Houston and pretend to be helping Charles write a book, a way for Lori to get Chad to come out and they could go out on one of their little, escapades together. But Lori was behind that email, and Charles knew it. And he confronted Lori about it, and he also messaged Chad Daybell about it. In addition to that, though, he also messaged Tammy Daybell. And whether she got it or not, we don't know. But this we do know, that within days of doing that, Charles Vallow was dead. And all of this was critical testimony because it supports the theory that Charles had uncovered the affair between Lori and Chad, and he was preparing to expose them. And that may have led to that revelation that Lori allegedly received, that Lori allegedly used to convince her brother, Alex Cox, to allegedly hunt down and kill Charles Vallow. But then came a chilling text between Lori and Alex referencing a guy named Nephi. Now, for context, in the Latter-day Saint canon of Scripture, a book called the Book of Mormon, Nephi, one of the prophets in the book, is told by God to kill a man named Laban in order to obtain sacred records. It was an act that was seen by some believers as divinely justified murder. It was only 2 days before Charles was killed, and Lori apparently texted Alex stating, quote, "I will be like Nephi, I am told, and so will you," close quote. Well, the testimony suggested that the text was a religious justification for violence, murder, reminding Alex that Lori had received revelations that Charles must die. Now, Duncan testified that he didn't understand what the reference meant at first, so he researched it. And he also heard Adam Cox state that Lori believed that she was on a spiritual mission akin to Nephi's, confirming what the investigator was fearing, that this wasn't a family squabble, it was a murder, and Lori believed she was divinely mandated to kill. You see, in the psychology of criminal behavior, this is massive because it places Lori's actions in this realm of delusional religious beliefs, a characteristic that I've often seen in cults and doomsday groups. It also gave the jurors some insight into Lori's mindset, this mix of spiritual grandiosity and fatal determinism. Now, the detective also broke down the timeline through phone GPS records and call records. And there we learned that Charles's phone, not Charles's phone left the house at 7:49 a.m. But that 911 call from Alex Cox didn't come until 8:36 a.m. That's 47 minutes later. And the medical examiner testified that Charles would have died within 2 minutes of being shot in the heart. And to the detective, this meant that Charles Vallow lay dead on the floor for 45 minutes before anybody called for help. The detective also noted that during this time, Lori took Charles's phone. She left the house, and she later returned like nothing had happened. Do you remember her giggling outside of the house about, "Hey, neighbors"? Well, in the world of law enforcement, this kind of behavior sets off red flags. You know, we call them clues. And the delay, the phone being accessed, the texts being read while Charles is already dead, all screamed of manipulation and possible evidence tampering. And Detective Duncan confirmed on that witness stand that Lori not only had Charles's phone, but she also knew the PIN to open it. She turned the phone back over to police later that afternoon when asked for it, but by then the damage was done. In fact, digital forensics would show that images of Charles's phone screenshots of texts and flight confirmations were found on Alex's phone and had been forwarded to Lori's iCloud account. And those iCloud accounts, they were two that were linked directly to Lori Vallow Daybell, Lolly Time and Lori for Style. Inside these accounts were thousands of pieces of digital evidence, photos, texts, audio recordings, and videos. They included texts between Lori and Alex about Charles being possessed by that zombie, Ned. A string of communications where Alex said, "Hey, quote, Ned just came by," close quote. And Lori would respond, quote, "Ned is still alive? It's not even a he, it's an it," close quote. You see how they're starting to dehumanize him? There were photos of Charles's life insurance policy with Lori named as the beneficiary, and screenshots of the policy change that showed Kay Woodcock, JJ's grandmother, as the new beneficiary, sent to Chad Daybell under a disguised name. And that's when Detective Duncan confirmed that the disguised name for Chad Daybell was Bubby. And investigators even found an audio recording of Chad using that number to contact a business. And while it wasn't brought out in court, that phone call, if I remember right, was to a mortuary regarding Charles Vallow's death. Now, this direct link between Lori and Chad, sharing financial and digital evidence after Charles's death, was the final nail in the coffin, so to speak. Now, I think the state hit a grand slam with Duncan's testimony. He walked the jury through forensics that debunks self-defense. He pounded home that 47-minute delay in seeking help for Charles after he'd been shot. And he showed the digital trail linking Lori to forged emails and Charles's phone. Finally, the state pounded home that it was Lori's religious belief that turned Charles into Ned, a possessed shell that needed to be destroyed. You know, this case has always blurred the lines between crime and cult, but Duncan's methodical testimony made that blur disturbingly clear. So for the jury, Duncan's calm professional tone probably underscored just how serious this case really is. The detective wasn't there to speculate or emote. He was there to show what the evidence taught him. But in showing it, he revealed a world of spiritual delusion, digital manipulation, and cold calculation. The psychology here is striking. Lori Vallow Daybell didn't just want Charles Vallow dead. She believed she was making some kind of a righteous decision. And if the jury believes that too, I think the defense is going to have an uphill battle. Which leads me to her cross-examination, where she finally had a chance to challenge Duncan's evidence, or to sink deeper into her own narrative. You see, during her cross-examination of Duncan, Lori attempted to challenge the interpretation of the digital evidence and the conclusions that were drawn from it. She questioned the relevance of Charles's dating life and the accuracy of the timeline presented. However, the judge sustained objections to several of her questions, deeming them essentially irrelevant. The defendant's cross-examination was long, layered, and at times surprisingly strategic. As someone accused of orchestrating the murder of her own husband, Lori's decision to serve as her own attorney has raised eyebrows. But in this moment, she didn't just posture and pontificate. She tried quite deliberately to land some punches. And in a few key areas, I think she did. So let's walk through the major moments of that exchange, highlighting where she scored points and where she faltered. Because one of Lori's more effective lines of questioning focused on the untested evidence. She methodically went through multiple items that were swabbed or collected but never sent to a lab. The baseball bat, the projectile removed from the floor, Charles Vallow's shirt, and the gun that was used to kill him. And Duncan admitted that none of these were DNA tested, and that he made the decision even later not to pursue it. He explained that the DNA and fingerprints are not time-specific, and given that the bat belonged to Tylee and was accessible to everyone in the household, testing was unnecessary. And I think these are valid points, but Lori pressed harder. She questioned him whether luminol was used to detect unseen blood, and it wasn't. And she asked why. Duncan answered that through the autopsy and bullet trajectory, he was able to make that conclusion without going any further. But here's the thing. This back and forth might have actually helped Lori plant a seed of doubt in the jury's mind about the investigative thoroughness, especially when she asked why the evidence hadn't been tested for nearly 5 years. So this might actually be a win in the Lori Daybell column. She exposed real gaps in the forensic workup, including Alex Cox's phone, which was never extracted, and only the call records were reviewed. But here's where she lost ground, in my opinion. Duncan remained steady and credible. He pointed out that based on blood patterns, trajectory analysis, and the autopsy reports, the scene told a compelling story. So she changed the subject and she started talking about digital evidence. And she used this part of the cross-examination to hone in on why Alex Cox's phone wasn't forensically extracted. Duncan admitted that despite the phone being voluntarily handed over, no download was performed, which was an unusual choice for a case involving a homicide with a digital trail. When he was asked whether he ever obtained actual contents of Alex's phone, his texts, apps, browser history, the detective answered no, just basic call records. And this allowed Lori to effectively argue that this omission robbed the case of potential insight into Alex's mindset, any instructions he received, and communications. So let's give credit where credit's due. Lori scored when she cornered Duncan into admitting they could have gotten more evidence, and they didn't. But for a jury already hearing about conspiracy theories and secret communications, this really could matter. Now, she clearly lost ground, though, when she overplayed her hand, slightly drifting by into speculation and argumentative questions, and the judge sustained several objections, dulling her momentum. So, Duncan provided really no help to Lori when she tried to reframe the events by suggesting that she, Alex, and Tylee were cooperative and compliant with police. The detective couldn't confirm nor deny firsthand, but he admitted that he had no reports of non-compliance. But when Lori pushed to suggest this compliance should weigh in her favor, the prosecution objected successfully multiple times. The judge ruled it out of bounds when she asked Duncan to characterize the behavior of other people based on reports he didn't personally write. But here's the deal on that. She blurted it out. Even though it was dismissed by the judge, the jury heard it. And while the judge may have counseled the jurists to forget about it, it's unlikely that they did. So in this arena, Lori scored by nudging the jury towards seeing her and Alex as cooperative, not evasive. But she failed when the strategy was undermined by the limits of Duncan's direct knowledge and those sustained objections. The jury may have picked up on the intent, but the impact was blunted. Then things got both strange and revealing. Lori took issue with Duncan's interpretation of her now infamous July text to Alex Cox, the "I will be like Nephi, I am told, and so will you." Duncan had earlier testified that based on research and conversations with other Latter-day Saints, he interpreted that reference as potentially implying that she had a divine mandate to kill. Well, Lori dismantled that by interrogating his research. Duncan admitted that he hadn't read the book of Scripture. Lori took the opportunity, though, instead of questioning him, to testify more about the fact that there are multiple prophets in the book named Nephi. And then she went off to pontificate on the Scriptures for a moment. Now, who knows if that moment might have mattered, though I'm considering it, in all fairness to her, as a win. She proved to the court, though, that Duncan wasn't a Book of Mormon scholar, and that his interpretation was speculative and arguably superficial. And this, some believe, gave her room to suggest that her religious references were being mischaracterized and possibly misused against her. So you could probably call it a win, but I think it's a stretch to say it's a win. But I'm trying to be complimentary. But Lori lost ground because all this religiosity didn't change the fact that multiple witnesses testified about her delusions that she was somehow a righteous person on a righteous mission, and that mission was to kill. Now, while Duncan's conclusions may have lacked theological depth, the context around Lori's statements remained damning. So as Lori Daybell ran out of her own length of rope, she switched to a sweeping series of questions about other interviews she felt like the investigators should have conducted. She asked why only one member of the family, an estranged member, Adam Cox, was used for the investigation. Duncan noted that Cox was available for some of the interviews and he had access to others, but Lori kept pressing, why weren't more family members asked? And he simply said, I didn't need them. So, again, to be kind to her defense efforts, she might have made a decent case that the investigation didn't cast a wide enough net, at least when it came to verifying context behind digital communications. But she failed to show that those other voices would have helped her in any way. The prosecution has implied that her family was fractured, with many privately concerned about her behavior. So I would have to say that Lori Daybell's cross-examination of Duncan was probably her most impactful moment in the trial. She came across more composed, less theatrical, and more determined to poke holes in the investigation, especially around forensic processing and the assumptions that investigators were making early on. So let's give her her due. She landed some real hits by highlighting the lack of testing on some pieces of critical evidence. She called out the failure to extract Alex's phone. She undermined the religious interpretation with some theological nuance, and she suggested that there were selective or narrow investigative processes involved. But then she faltered badly by her overuse of speculation that led to multiple sustained objections. At times, she crossed into argumentative or rhetorical territory rather than simply questioning. And her attempts to portray the investigation as biased were undercut by the volume of digital evidence that implicated her in the death of Charles Vallow. So in the end, the cross may have helped her jury's optics slightly, but the facts in the forensic timeline remain devastating. The phone data, text messages, delays in calling 911, and the evidence that she was using Charles's phone after his death are working against her.
Detective Duncan, when did you become the case agent?
I believe it was June of 2020.
Okay,
So July 11th, obviously, I was there at the house.
right.
Shortly after that, I had another homicide and my time was occupied with that. And it was several months later that I offered to help look at records because they were so much. And I'd always done that kind of in the background, but never really took a deep dive into them until that June 2020.
Okay, but you were kind of involved, so you kind of knew what was going on in the investigation during
Somewhat.
during that time, that year in between,
Yes, yeah.
before you became the case agent.
Correct.
But not totally deep dive, but you kind of knew what was going on.
I understood it.
Okay.
Yes.
So let's go over that day again real quick. When you were there, what time were you there at the scene, from when to when?
I believe I arrived shortly after 9:15.
Okay,
And I would have left probably 4:30.
okay. Were you at the house that whole time?
Yes.
So
Well,
you didn't.
Let me back up.
Oh, sorry, go
I
ahead.
did leave for a short period of time to obtain a saw that we would need to cut that piece of flooring out and the baseboard.
Okay.
But then it came back, yes.
So you were at the scene that whole time, besides the time you went to get the saw?
Correct.
You didn't go to the Chandler Police Department?
No.
So you weren't there during our interviews?
No.
Okay. So, and you had mentioned something about you couldn't go in, I was confused. You couldn't go in until after the search warrant, but you were in before that, right?
No. So obviously your first responders, your police officers, the firefighters, they're going in to preserve life and treat the victim in this case. Then they back out. At that point, we will not let anybody in, given the circumstances of this case, until a search warrant is actually signed and executed. So we will wait outside the threshold of the house until that search warrant is signed, and then we will begin our investigation.
So I'm still confused. So you didn't go into the house until after the search warrant, or you did get to go in beforehand?
No, I didn't go in before. I waited until after the search warrant.
Okay. So you had testified, I'm still confused, sorry.
And I'm going to object again to the defendant testifying.
Just ask the question.
You had also indicated that you had gone in and that Charles was on the floor. Is that correct?
I think the question was asked of me is, what did I see when I went in? And so that, and I would say after the search warrant we went in, that's what I saw.
But he was already gone in the ambulance at that point?
He never went in an ambulance.
Charles didn't go in the ambulance?
No, he went with the medical examiner's office.
So what time did he leave?
I can't give you a specific time on that. I have to look at the medical examiner's office information for that.
But it was after you entered at 11:50?
Yes, it was way after that.
Okay. So then when you entered, what did you do at that point? Can you kind of walk me through that?
Yeah, so when I entered, obviously I made my general observations about what I saw in that room and of the body. And then talked with Detective Coons about what needed to be done next.
And what did you guys do next?
So we came up with a game plan as far as how to process the scene, which direction, who was going to do what. Like I indicated, I was tasked with collecting that firearm and was also tasked with kind of looking through the house for any kind of blood evidence that might be present. The other task that I had, when we were ready, I contacted the medical examiner's office to report the death to them.
And did everyone leave the scene at 4:30? Is that kind of the timing when people were clearing out? Or?
Yeah, some might have stayed behind, and a lot of our ID techs like to sit in their cars and type their notes, that type of thing. But right around that 4:30, 4:45 is when the search warrant was completed.
Okay. And then there had been a walkthrough, is that correct?
Yes,
And so Alex had come back to the house just after 3-ish?
I believe that could have been the time, yes.
Okay. And then were you present during the walkthrough?
I was.
And who else was present?
Detective Moffitt, Detective Werther, Detective Coons, myself, and I want to say crime scene technician Jordan might have been there as well.
Okay. Did each of you write reports on that walkthrough then, since there was no recording of it?
That would have all been included in our report, not a specific walkthrough report, but in our original narrative, yes.
Everyone would talk about it, mention it, their perspective?
Not everybody has to, as long as somebody or one or two people wrote about it to know that it happened. Yeah.
Right. So since there's no recording of it, though, someone is assigned, like, because Moffitt is the case agent, or who would do that? Be assigned to include it in the report, for sure.
It's different. I'll give you the example. If you look at probably my report compared to Detective Coons' report, you might notice, similarities in there. You might notice stuff that I went into more detail on, or he went into more detail. But it depends on whether they write it or not. They could just put something as simple, I was present during a walkthrough.
Okay. So since you became the case agent, have you read all the reports?
At one time or another, yes, I have.
So when you became the case agent, you were kind of aware, so you knew what had been done in the investigation, is that correct?
Yes.
And so you knew who had been interviewed, is that correct?
Yes.
And you knew what had been tested or not tested at that point?
Correct.
So the bat was tested for fingerprints. We learned that in the testimony, is that correct?
Correct.
And the results were inconclusive.
Correct.
And so there were no latent prints were identified. That's correct.
Correct.
And there were prints, but we just don't know whose they were. Is that accurate?
Sounds about right, yes.
Now, we learned that the bat was swabbed for DNA and sent to the lab. Is that correct?
Yes.
And was that ever tested?
No, it was not.
And why not?
When making this decision, you have to look at the probative value of that and what that would show or what a test would prove. DNA and fingerprints are not time specific. That bat was owned by Tylee, to our knowledge. It was in a household where you lived. It was in a household where Alex was. And at one point, based on the fact of when we understood the bat to have been purchased, Charles was living in the house as well. So that bat was accessible to all those people. So if at one point during that time that person touched that bat, all that it would be saying is that somebody touched that bat at some point, not during this incident.
Right. But there was no blood found on the bat, is that correct?
Correct.
But would that be able to be told from DNA?
There was nothing that was visible that could see, like if blood dries or anything like that. There was nothing that would indicate that here's a spot we need to test for that particular, for blood.
Right, but would DNA tell if there was blood? Could they find out if there was blood on the bat from the DNA test?
Once again, blood is, you would see if it dries and crusts, then you would see that particular blood. DNA comes in many forms. It can come in touch, it can come in sweat, blood, but you would think that blood would be visible at that point to be able to test. And we did not see anything like that.
Okay, so if there was none of Alex's DNA on the blood, wouldn't that tell us something? I mean, on the bat at all, then wouldn't that tell us something?
If there were none of Alex's, it would just mean that Alex never touched that bat at any time.
And wouldn't it tell us that Alex was never hit in the head with that bat?
Once again, it's not specific. I can't, if there was blood on the bat, then yes, we would test for that. But there's no visible blood on the bat.
I understand that, but when you're doing an investigation, are you not trying to figure out what happened?
Yes, and that's what we
Don't
did.
you want all the information to do that?
Yes.
And so whose responsibility would it be to request the DNA testing from the swab that was taken?
Once again, that would just show, it's not showing that it's blood. There's no blood on the bat. It was just showing that a DNA swab was taken of that particular area to be able to test later on. But there's no discoloration that would show any kind of blood.
And who in the Chandler Police Department would be requesting that DNA to be tested? Who would have to do that?
That'd be me.
It would be you?
As the new case agent, that would be me, or Detective Moffat at the beginning.
And so Detective Moffat never did that, is that correct?
Correct.
And you never did that, is that correct?
Correct.
Okay. So if Charles' DNA was on the bat, then wouldn't that tell us something also?
Did he touch the bat at some point?
Yeah, that he took it from Tylee, like she said in her interview.
And I'm going to object and move to
Sustained.
strike that.
The jury should disregard that last question, that information is not in evidence.
Detective, wouldn't that have answered some questions for us in your investigation?
I don't think it would have, no.
Okay. We learned that the gun in testimony, that the gun was tested just last month, is that correct?
Correct.
And who requested that test?
I did.
And why did you request that test?
So on firearms, immediately after we have a firearm case, we have the ability to utilize a system called NIBIN. NIBIN is run through the ATF, and what NIBIN will do is we can fire a particular firearm that we have control over and obtain casings from those. We could then take the casings from the scene casings and then compare those together. We already knew that that gun fired those casings very early in the investigation, as a NIBIN report provided. However, ATF will not testify in court. So playing the balancing game of when a trial will begin and whether a trial will even happen, I do not like to make more work for a firearm analyst than I have to. So when we know that we are in and going to trial, then I will send that over to them because they were the ones that will testify to that.
Okay. So it wasn't after my investigator suggested that none of the guns had been tested
No,
that you
no.
ordered that test?
I never spoke to your investigator about that either.
Okay. So, Detective, when did the Chandler Police Department take possession of the gun?
On July 11th?
And then it was tested in March, is that correct?
Correct.
And then we've established through expert testimony of Detective Coons that the floorboard was not tested either, is that correct?
Correct.
And he also established that the projectile was not tested either, is that correct?
Correct.
And Detective Coons also confirmed that no tests were done on my husband's shirt, is that correct?
Correct.
And then when you became the case agent on this case, why didn't you request any of these tests?
Because I was confident that based on the medical examiner's report of an entry wound to the lower left quadrant, an exit wound to the upper left rear shoulder, and a corresponding defect, or what I would refer to as a bullet strike on the floor, if you take those 3 points and match them up, then there's no other explanation other than Charles was laying on the ground at that time.
So the medical examiner said he could not say that he was laying on the ground for sure, but you're saying that in your detective opinion, you know that for sure?
I believe so, yes.
And so were you there to witness it with your eyes?
No.
Detective, to your knowledge, did my brother and my daughter and myself willingly comply with everything asked of us by law enforcement on July 11th, 2019?
I can't speak to that, no.
Did we answer all the questions asked to us?
I have nothing to say you didn't.
Did we follow all directions given to us by law enforcement that day?
I'm going to object to speculation and foundation as to how this detective knows that. He's already said he wasn't at the station.
He's the case agent, Your Honor.
But he can testify to what he observed for himself, so if you want to tailor your question, go ahead.
Would you say that according to every report and every detective that you've talked to and anything else, that you would say that we fully complied with law enforcement that day on July 11th, 2019?
Object to hearsay.
I'm going to sustain the objection to the form that it was asked.
So according to all the reports that have been given by everyone who was there, and you're the case agent, so you're in charge of all of these people, is that correct?
I'm not in charge of them, but I have read the reports.
So you have read the reports,
Yeah.
and as far as you know, to your knowledge, we fully cooperated with law enforcement that day on July 11th, 2019?
I'm going to again object to hearsay. And lack of personal knowledge.
Sustained.
Has it come to your knowledge that we did not comply with everything?
And I would object to the exact same thing, lack of personal knowledge and hearsay.
He can answer that question.
Can you answer that again?
Have you come to the knowledge that we did not comply that day for any reason?
I have not.
Okay. Did I turn my husband's phone over when asked?
Yes.
Did Alex turn his phone over willingly?
I am not sure when Alex, or if Alex turned his phone on. I'm not aware of that.
Okay. So is there a body cam where his phone was placed into an evidence bag? That's correct.
I do remember seeing that, yes.
And then the evidence bag is put into the front of the police car where he was taken to the Chandler Police Department. Is that correct?
I didn't see that, but I trust the fact that it was taken at that time, yes.
And so according to that body cam, it looked like he turned it over on request.
And I'm going to object to speculation.
You don't have any knowledge that he didn't, is that correct?
I'll allow that last question.
I don't have knowledge, no.
Okay. So do you know who had taken possession of his phone at that point?
I don't.
Do you know who drove him to the Chandler Police Department?
Well, through this hearing, Officer Krautheim.
Oh, that's right. The one I couldn't remember how to spell.
Again, Your Honor.
Sustained, please don't testify.
Was a copy of Alex's phone made by the Chandler Police Department?
I don't know.
You don't know?
There's so much information. I don't know whether we received his call detail records or an actual copy was made. I don't know.
So you're the case agent.
Yeah, I'd have to look and see if that was the case.
So you're the case agent, and you don't know if the person who shot my husband's phone was ever...
Yeah. At this moment, I don't recall.
So there's no Cellbrite of it. Is that correct? In the discovery?
I think the only thing that we have is his call detail records, which would be from his cellular provider.
So what would the typical protocol be for you to, if someone handed over their phone, wouldn't it be to do a digital download of it?
So that can be one of two ways. It could be under a search warrant to do that, or it can be under consent to do that. I do not believe I don't believe that his phone was extracted at that time.
So he would have to given consent? Is that what you're saying?
Or a search warrant, but that would have been through Detective Moffat.
So Detective Moffat would have had to get a search warrant and then he would download it?
Based on their conversation, whether Alex would be willing to do that or whether a search warrant was needed, but that was Detective Moffitt's call at that time.
And he decided not to do that.
I don't know what his process is or his thought process.
Well, I'm saying that he did not do that, and you're the case agent now, so you would know if that was done, correct?
You're asking me to speak for Detective Moffitt, whether it was done or not?
No, I'm asking you to speak as a case agent now if you know if it was done or not.
I believe it was not.
Okay. Do you think that would be important to your investigation?
Absolutely, knowing what we know now, yes.
Okay, you're a detective, right?
Correct.
You have to look at all the angles, right?
Correct.
You don't know what happened, right? You just stated that you weren't there, right?
Correct.
So wouldn't that be crucial information that the police department didn't bother to take?
Once again, I don't know what the conversation with Detective Moffitt and Alex was and what his reasoning for not. Would I have taken it? Yes.
But that was not your call at the time.
Correct.
And so in lieu of that, what did you do to try to obtain that information?
We got his call detail records through his company.
And so is it safe to say that it's much better to have the actual phone to do the extraction so that you can have everything that was on the phone?
Yeah, but you can also obtain a lot of that stuff through other means, through iCloud records, Google records. But yeah, it is nice to have that phone.
So would you call that an oversight by Detective Moffitt?
Object to speculation.
Sustained.
So was the phone then returned to Alex that day?
Yes,
How did that happen? Was it just handed to him or?
I'm not sure.
Okay. And that would have also been Detective Moffitt's call.
Correct.
And we haven't heard from Detective Moffitt, is that correct?
Correct.
One thing is clear though, Lori Vallow Daybell is not going down without a fight. And in this round, she might have scored a point or two. But regardless, it was nothing compared to the prosecution's effective digital forensics that established a timeline and motive, highlighting Lori's communications that suggested premeditation and a belief in religious justification for murder. The delay in calling 911 and the actions taken during that time further undermined the claim of self-defense. I've said it before, but Lori's decision to represent herself and her approach to cross-examination appear to weaken her position. Her questions often lacked focus and failed to counter the prosecution's narrative effectively. The judge repeatedly provided interventions to redirect her line of questioning, underscoring the challenges she was facing in mounting a credible defense. Now, this trial has shed light on the psychological dynamics at play, particularly the influence of apocalyptic beliefs on Lori's actions. Her conviction, if you believe it was that, and not an excuse to righteously continue an affair with Chad Daybell, her conviction that Charles was possessed and her invocation of religious narratives to justify his death suggest a detachment from reality and a susceptibility to delusional thinking. And experts have noted that such beliefs, when combined with charismatic leadership and group reinforcement, can lead individuals to commit acts that they would otherwise consider unthinkable. Her behavior during this trial, including her decision to represent herself and her confrontational cross-examinations, may reflect a desire for control and a belief in her own righteousness. Now, this aligns with patterns observed in individuals who exhibit narcissistic traits and a lack of empathy, particularly in cases involving familial violence. And to support this idea, I want to just talk about how the day ended. Because after the state rested, Lori threw one of the more powerful curveballs I've seen as she tried to regain a little control in this court proceeding. She decided to argue a Rule 20 motion. Now, these Rule 20 motions are often filed as a matter of strategy or preservation. It allows the defense to argue and appeal later that there was never enough evidence to justify a conviction in the first place. So even if she didn't believe the judge would grant it, she's laying legal groundwork for the appeal. So let's just pause for a moment and listen to that Rule 20 argument she made.
Your Honor, I'd like to address a Rule 20 motion first.
Go ahead.
Okay. The state has failed to show substantial evidence for count 1, conspiracy to commit first-degree premeditated murder. The state has provided no evidence that I agreed with another person that any one of us would engage in certain conduct that I intended to promote or assist in this premeditated murder. Crime premeditated murder requires the state to establish a person caused the death of another with premeditation. The lack of evidence to show any evidence of a conspiracy to commit murder, there was no plan to murder Charles. No evidence has showed that, in fact, evidence suggested self-defense on the part of Alex. So I would like to put that on the record.
All right. State want to put a response on the record?
Yes, Your Honor. Looking at the evidence in the light most favorable to the state, there's sufficient evidence based upon everything from the iCloud messages from between Alex, the defendant, and others leading up to July 11th of 2019, that Alex Cox was invited over by this defendant, knowing that they were going to be having an intervention and knowing when Charles would be there and bringing a handgun over with him. The timelines on July 11th of the killing of Charles Vallow and the fact that the number of shots and the physical evidence at the scene, the statements by the defendant to Detective N. Clan that she took Charles Vallow's phone and would not give it back to him, the motive for money, and especially the defendant's motive for having an affair with Chad Daybell, all of those looking at together in the light most favorable to the state, the defendant or the jury could find the defendant guilty of conspiracy to commit first-degree murder.
Last word. Do you want to add anything?
No, Your Honor.
All right. The standard is whether or not a reasonable juror whether or not there's substantial evidence for a reasonable juror to find the defendant guilty. The court does find that there is substantial evidence that a reasonable juror could find the defendant guilty. The court will further add that the jurors are the ones who judge the credibility of the witnesses, and it's ordered denying the Rule 20 motion. Are you going to present evidence tomorrow, either through witnesses or through your own testimony?
No, Your Honor, the defense will rest.
Lori stated that the state failed to prove there was a conspiracy to commit first-degree murder and that there was no evidence presented that she agreed with Alex to kill Charles. She claimed that the evidence actually pointed to self-defense by Alex, and for those reasons, there was no basis for conviction, especially not premeditated or conspiracy. Now, this was her shot at getting the case tossed out before the closing arguments, but the judge quickly denied it, reminding everyone of the low bar at this stage of a trial. That bar is if any reasonable juror could believe the state's version of events, the case moves forward. And in this one, the state, in his opinion, has presented mountains of circumstantial but powerful evidence. So I'm left wondering, has Lori Vallow Daybell thrown in the towel, or was this a legal Hail Mary? Simply one more chance at her gaining control. It was a performance of such for the jury, even though the jury wasn't in the room, because Lori has been treating this courtroom like a stage. Raising that motion could have been her way of emphasizing that she believes the prosecution failed, possibly hoping that some jurors will hear about it or consider the logic in her argument during deliberations. But ironically, it also reminds everybody that she didn't put up a defense, which is risky if jurors were expecting more. So Lori may truly believe that Alex acted alone in self-defense and that her religious beliefs justified his actions. She may think she didn't conspire because the plan was God's and not hers. Now, if that's true, then in her mind, the state did fail to prove its case because she doesn't believe she did anything wrong and that God sanctioned it. Well, this is delusion reinforced by religious righteousness. It's not courtroom strategy. And one other option could be that she knows she's lost, but she wants control. It could be that in her final grasp of control in the courtroom, where her attempts to act as her own lawyer have backfired, that this is that last moment of perceived authority, a last chance to tell the judge and the prosecutor and the jury, if they hear it, you didn't beat me, I'm still in charge. It's courtroom theatrics, and it's not lawyering, but it's classic Lori Daybell. And don't forget, whether she purposely did it or not, she preserved her right to appeal by blurting that out. Ah, the sweet feeling of control. It might actually explain why she rested without putting on any witnesses or testifying herself. It's risky, but it's possible she simply had nobody who would help her case, and she didn't want to risk cross-examination of those witnesses who might end up reinforcing the state's narrative. So we're left wondering, will Lori Vallow Daybell testify on Monday? Any legal counsel she's received is probably encouraging her not to, but perhaps she thinks she's already testified, since that's what she did throughout this entire state presentation. One thing's clear, though. I think she found out the hard way that lawyering is tougher than it looks. Now, her courtroom effort highlights what happens when narcissism meets the criminal justice system. Representing yourself isn't a brave and noble thing. It's reckless, especially if it's a capital case involving digital forensics, conspiracy, and complex timelines. Lori not only overestimated her ability, she misunderstood the fundamentals of criminal law. She may genuinely believe that the state failed to prove its case, or she may simply be out of cards to play. But either way, after her possible testimony on Monday and her closing argument, which she says will be short, the only people that are left in control are the jurors. So drop your thoughts in the comments down below, because I really want to hear what you think. Was Lori's cross-examination a stroke of strategy or a slow-motion disaster? And what about Rule 20? Let's talk about it and keep things kind and constructive. And folks, thanks for watching Profiling Evil. Your support means a lot. And I hope you're checking us out on Facebook, Instagram, YouTube, and Twitter. That way you'll get real-time updates, exclusive insights, and behind-the-scenes content as we follow the Daybell case and many others. And if you like audio podcasts, please subscribe to Profiling Evil's audio podcasts on your favorite podcast platform. That way, you'll be able to dig deeper into cult behaviors, psychological manipulation, and the trail of destruction left by predators, even when you're on the go. And if you're craving more true crime, head over to profilingevil.com, where you'll find our story maps, and sign up for the BOLO while you're there. And please consider picking up my book, Deceived, an investigative memoir of the Zion Society cult. You can get signed copies by going to the website, or you can find that book anywhere through Amazon throughout the world. But I think the book will help you understand cult dynamics and some of the things that have been going on in a case just like the Daybell case. Thanks for your support of Profiling Evil. We'll see you soon at the next crime scene.